Now we come to the point of the learned advocate for the complainant that when the case was proved, it was obligatory upon the trial court as well as the first appellate court to pass the maximum sentence provided for the offence. Full stop. The arguments of the learned advocate is that ocular and documentary evidence as well as the motive for the offence are proved by the prosecution that the accused were inimical to the deceased on account of the marriage of Shanaz Bibi with Waris Hussain Shah, which led to the murder of the deceased. Full stop. This fact is almost stated by all the prosecution witnesses that the accused, on account of marriage of Shahnaz Bibi with Waris Hussain, brought into being by Qasim Shah deceased, were annoyed and off and on used to threaten the deceased of the dire consequences. There is no doubt that when an offence is proved, it has to be met with the maximum sentence provided therefore. Full stop. However, there is no yardstick to restrict or curb the discretion of the trial court while passing the sentence. Full stop. It is the circumstances of each case which justify the severity or leniency in passing the legal sentence, unless the law itself provides the minimum sentence, in which case the discretion does not matter. Full stop. In the case in hand, it was open to the court to impose any sentence provided by Section 3 of the Islamic Penal Laws Enforcement Act, 1974. Full stop. The trial court as well as the first appellate court in its wisdom felt pleased to impose the sentence of imprisonment instead of qisas or death. Full stop. We, in view of the circumstances of the case, also feel inclined to hold the same view and endorse the reasons given by the courts below for not awarding the sentence of qisas or death. The life imprisonment as provided in section 55 and 57 of the Penal Code, when the trial court passed the sentence on 24/3/97, was 14 years, which now stands substituted by 25 years under Act. It is the 14 years period which applies in this case and not the substituted one. Full stop. The 14 years substituted by 25 years is provided as the term of imprisonment under the above referred sections of Penal Code for the offence of murder as stated above, but the case in hand being under the Islamic Penal Laws Act, any of the sentence provided under Act is to be awarded in this case. Full stop. As discussed above, the normal and maximum sentence provided for the offence of murder under section 5 of the Act is qisas or death, pending upon the nature and standard of evidence as visualized by Act. Full stop. However, the court is also empowered to award any of other sentences provided by section 3 of the statute, one of which is imprisonment, which has been awarded in this case. Full stop.